entertaining and informative radio for the Sunshine State.
It's time for FLA Law, brought to you by the personal injury attorneys of Perinick, Caulfield, Averill, and Noyes. This hour will be informative, along with taking your questions and comments. Now, here are your hosts for today's show.
That's right. We are live in the studio, as always, every Tuesday with FLA Law live on the radio. And we are the lawyers of Perinick, Caulfield, Averill, and Noyes, personal injury attorneys, coming to you live with our live legal call-in talk show. As you know, every Tuesday we are here with special legal guests from all over the county coming in to talk to you about legal questions. Sometimes you have, of course, us at the law firm of Perinick, Caulfield, Averill, and Noyes, and sometimes you get lucky and you have a special guest, which we do have tonight. So I'm excited for our listeners and our viewers online who are going to get a special treat tonight with our guest who is with us from a different law firm, different area of law. And so it'll be great to get your questions answered live on the air. So with that being said, thanks you for tuning in. And if you are going to call in tonight with your legal questions for personal injury or family law or whatever questions you might have, here's the phone number. It is going to be 727-441-3000. Again, that's 727-441-3000. That is how you're going to call into the studio tonight to get your legal questions answered live on the air. But of course, if you're like most people, you don't necessarily want to call in or don't want to hear your voice on the radio, you can still leave your comments and questions online. We are streaming live right now on Facebook. Hopefully, if you have found us, you should see us in the studio. Our camera's right there for our special guest, so she knows where to look. But if you look for us on Perinick, Caulfield, Averill, Noyes Injury Lawyers on Facebook, that's spelled P-E-R-E-N-I-C-H. You should see the little red circle around our logo. That lets you know that we are live. Just click on that. You should be able to see the live feed. You'll see us in the studio as we're talking tonight throughout the show. But you can also leave your questions right there in the comment section. I will see those questions and I'll read them out live over the air for our guests tonight as well. But also, if you don't have, let's say you don't have social media, you're not on Facebook, we are also streaming live on YouTube right now as well. So feel free to check us out on YouTube. You'll see our live stream. You can comment your questions there. Perinick, Caulfield, Averill, and Noyes Injury Lawyers. So that's how you find us tonight. That's how you get your questions in. And we have a great show with a great family law attorney. With that being said, let's not delay any further. Introduce you to who we have in the studio with us tonight. This lovely lady is actually a classmate of mine. We both were in Stetson at the same time. Can't remember if I was a year or two ahead of you, how many years, but we were going through the process together as law students, and we became friends during that time. But she went off and started her own firm out of law school and has been doing very well since then. I'm extremely proud of what she's done. How many attorneys do you have working at your firm now?
I have 2 now.
Wow. So you've expanded. She's got 2 attorneys working with her. And she's going to obviously tell you a little bit more about her, but tonight, we're going to focus mostly on family law, but she does do other things at her firm. She's a mom of a little one. We both have 2-year-old boys, so yes. She and I commiserate when it comes to that. They say don't call it terrible twos, but it's a lot.
Also been sick for 2 years straight.
I sympathize wholeheartedly. So she and I have a lot in common. I love her to death. We've also served on some boards together for the Menace Bar Association and the Clearwater Bar Association. She is one busy lady. I could go on and on reading her bio, but I'm going to let her talk a little bit, just give you a little bit of an overview of who she is and what she does. Feel free, Karis.
Thank you so much for having me, Jackie.
Absolutely.
So to everyone, my name is Karis Campbell. I'm the owner of Golden Key Law Group located in Pinellas Park. We practice primarily family law, but we also handle transactional real estate matters, criminal, and a little bit of estate planning.
Okay.
I've been practicing for about 10 years. And as Jackie mentioned, I'm super involved in the community. I'm involved with the Clearwater Bar Association, Fred G. Minute Senior Bar Association, and others. Mm-hmm. And I'm so happy to be here today to share my knowledge about family law.
Are you still on the ends of court as well?
Still attend,
Oh my
Kanaka's
gosh.
ends of court. Still
You
sit
just
on
have
the,
your hands in everything. God bless you.
Yes. Well, I'm terming off of the rules committee,
Okay.
thankfully, for the Florida bar. But
All right. So you were still serving on the Florida bar. You were in the ends of court for, was it, how do you say it? Kanakaris. You still involved with CBA, Clearwater Bar, which some of our listeners may remember. We had the director, Teresa Conti, on the show some months back. And then Menace, you're still involved with Reggie Menace, which is the Minority Bar Association in Pinellas County.
Yes.
What else did I miss?
Stetson Advisory.
Yes, you're on the BOSA. So that's the Black Law Students Alumni Association, which we both serve on that as well. What else? My goodness, girl.
Listen.
I don't know how you do it all. I feel like the few things, I do half of what you do, and I feel overwhelmed with that, but
one day at a time.
Well, let's get into it. Obviously, you let us know that she is the founder of Golden Key Law Group. So before we get into what we're going to discuss tonight, you mentioned that you also do some real estate work, a little bit of criminal. And what else do you guys do?
We do some estate planning.
Estate planning, awesome. So keep that in mind, folks. We're only going to be talking about family law tonight, but at the end of the show, we're going to have her give you all her info, how to reach her, how to find her online. So that way, if you have other issues that maybe we didn't discuss on tonight's show that you'd like to consult with her and reach out to her office for a consultation, you'll get all that information at the end of the show before we wrap up. So just keep that in mind, that she is not just family law, but her firm handles several other practice areas that you can certainly reach out to her about. They do not do personal injury. So if you need that, that's us. We've got that covered.
Yes.
We got that covered for you. So with that being said, today is the day before Valentine's Day. This is the month of love. And I heard a rumor, I don't know if it's true, but I heard a rumor that the day after Valentine's Day is one of the busiest days for family law attorneys. Is that true, or is that just a urban legend?
Listen, I think it's always busy for family law attorneys. But
I feel like people look, he didn't get me what I thought he was going to give me. I realized that I'm not the main person in his life anymore, and I need this divorce, or whatever the case may be. So that, to me, that was funny when I heard that. I was like, well, that kind of makes sense. People are not happy the day after Valentine's Day if they didn't get what they thought they were supposed to get.
Listen, I've gotten calls on Christmas Day even.
Oh, my God.
There's no
rhyme or reason to it, huh?
No.
Look, I would imagine the holidays can get touchy when it comes to matters of the heart. So it's just ironic that we have a family law attorney here with us in the month of love, because guess what? At the time that you get together, everything's happy and you expect to be together forever, but that's not always the case. And that's when you need somebody like Miss Attorney Campbell to kind of help you navigate when love doesn't last, right?
Yeah, it takes about 5 minutes to get married and at least a year to be divorced on average. So
let's get into it, because that's obviously something that, in the personal injury realm, that's one of the biggest questions we get is, how long is this process going to take? You know, they're taking away from my life, my livelihood. This has just been a huge impact on my life. How long is it going to take for me to get justice? So I'm sure that when people come to you, when they're getting ready to, or they're even contemplating a divorce, that's one of the questions they might have, right? Is what should I expect? How is this process going to play out? And how long is it going to take? So let's kind of jump into that.
Yeah, so it really just depends on the complexity of the case and whether children are involved, assets, debts of the sort, and whether the divorce is contested or uncontested, right? And so,
could you explain to listeners what contested means?
Sure. So a contested divorce means that the husband and wife do not agree to the core issues that need to be determined in order to be divorced.
Right.
And those issues tend to be, we call it the PEACE, according to the PEACE acronym, funny enough, parenting issues, equitable distribution, which is the division of assets and debts, alimony, and child support.
Right.
And so if they agree upon everything, then that's called an uncontested divorce.
Okay.
And typically, if everything is agreed upon, you can be divorced rather quickly, probably in a few months.
Really? Okay.
But if parties are at odds, then it can there's no timetable.
Right.
The courts like to resolve cases within a year or by the 1 year mark, but it really just depends on what's at issue, the discovery that's needed to litigate the case, and then, of course, the court's availability for court time.
All right. So a lot of it's probably governed by the court's calendars and getting in for this, that, and the other. So maybe, I guess what I want to kind of understand is the process, because I really don't know much about family law. I haven't had an opportunity to really go into litigation with that. I've strictly done personal injury my entire career. So I know that from the personal injury standpoint, there's a pre-suit process where there's no lawsuit filed. We try to do things to get the case resolved without having to file a lawsuit. And then if we're unsuccessful in the pre-suit phase, then the lawsuit is filed. Of course, there's discovery. The discovery process can take a certain period of time according to the rules. And then certain counties, you must mediate before you can even get a trial date. Of course, if you impasse at mediation, then you can get set for trial. But this process can be 18 months. Like you said, it could be a long time. So with family law, is that similar? Do you try to resolve things without going to court, or do you you're right in court as soon as you file for divorce?
So typically we start with filing a petition.
Okay.
Petition for dissolution of marriage. Now, there are times where only on, few and far between where you may send, a marital settlement agreement with a cover letter before filing the petition. And typically that's when the attorney is trying to pinpoint whether it's going to be contested or uncontested.
It's a little bit of a tool, to feel them out.
But for the most part, we start off with just filing the petition.
Okay.
And then after filing the petition, we have to serve the other party. They have 20 days to respond.
Right.
And then we're required to complete financial disclosures, and that's mandatory, the financial affidavit and mandatory disclosures.
Right. And I had a little bit of experience with that in law school. I volunteered at Gulf Coast Legal Services, and a lot of those clients were indigent. They couldn't afford to go through the process, or they were dealing with some sort of domestic violence issue. So there weren't a lot of assets or things to really put in there. But I can remember the form being really detailed and kind of comprehensive.
Yes.
So what kind of information do you have to disclose? If you're going to file for divorce, then you should be prepared to disclose X, Y, and Z. Could you explain that?
So the financial affidavit basically includes, it's like you said, it's a pretty lengthy document.
Mm-hmm.
It includes income information, your monthly income information. Think of it like almost like a spreadsheet, like a budget sheet. You have to list all of your bills, all of the bills that you have. There's a place for you to list additional bills that's not listed. And then you have to list all of your assets and debts.
Okay.
And there is now actually a law that passed that does not require, in some cases, for financial affidavits to be filed, but I don't like it. I think it should be filed.
New?
It is very new. Yes, it's very new. They're allowing parties to waive the filing of a financial affidavit if they agree in certain cases.
If they agree, okay. Mm-hmm. So is this something that is only done based on the agreement of the parties, or there be other ways that you could get around disclosing your finances?
Agreement, but we don't. Family law practitioners, I think for the most part, we don't like it.
I was going to say, I don't think it would ever be beneficial to agree to that, because then how do you really know what you're dealing with as far as the assets and liabilities and so forth? Exactly,
because there are times where people don't disclose, or they don't disclose enough to put the other party on notice, and so if that happens, it makes it incredibly difficult to address that issue in the future. So I will be recommending to all of my clients.
don't agree to that. Don't waive the financial disclosure.
No, to absolutely do a financial affidavit. And then the second document that I referenced was the mandatory disclosures, which is a comprehensive list of documents that has to be provided to the other side. And
so that's different from the financials.
Yes.
What kind of things would that be?
So that includes bank statements, credit card statements, W-2s, tax returns for the last couple of years.
Okay.
Yeah.
So that's similar in the sense that when we do personal injury discovery, we ask for a lot of that too. So at the end of the day, both sides get to delve into whatever the allegations of the complaint are or the defenses. So if we're claiming that our client lost wages or they've been harmed in some other way, then we have to substantiate that by providing the W-2s and the income and that sort of thing. So that makes sense.
Yeah.
So on the family law side, then going back to the process, I would imagine that before you start talking about mediation or trial, you're going to go through this kind of disclosure part, right?
Yes, it's required that you file the financial affidavit and mandatory disclosures within 45 days of filing.
Okay.
And you're required to file the financial affidavit before scheduling mediation.
Gotcha.
Mm-hmm.
So I would imagine, I could be wrong, but I would think this may happen often where you get the disclosures from the other side and your client's like, this is not right. There's more in there. They didn't put everything in there. Like, what do you do when that happens?
Well, we have to send a good faith letter, and then the compel process starts to happen where we'll, file a motion to compel, schedule hearings to make sure that they're in compliance with the rule.
Yeah. Do you have to have more than just your client's belief or suspicion that this is not accurate, or is there something more you have to base on? Like, for example, if you get a full completed disclosure that looks like it's right, just from they checked every box, they filled out every line, but your client says, no, this isn't right. There's things that are missing. Is that enough to challenge it and ask for more information or to go to the court and compel further disclosure? Or do you need something else to back it up?
So the mandatory disclosure list is very comprehensive in the sense that a lot of the documents that must be provided are years worth of documents.
Yeah.
And so typically if something is missing, there's some sort of indication that
there's a red flag somewhere.
Right.
Gotcha. Okay. Well, that makes sense then. So then once you kind of go through what was produced, it starts to kind of point to what might be missing, if you will.
Correct. And they have to certify that everything was produced. Yeah. And then if it comes out that it has not, there's actually no bar on a spouse coming back to court on that issue.
Could you get sanctions to the other party for failing to properly disclose information? Okay.
Absolutely.
That's good to know. Interesting. So then after you do all that, you get your disclosures and the financial documents and everything is kind of in and you feel like you've gotten everything comprehensively, then is that mediation the next step?
Yes, mediation's the next step. It's mandatory.
Okay.
And you're actually required to go to mediation before the court will hear any contested matters, contested hearings. And so we try to get that mediation scheduled within the first few months.
That makes
sense.
We could. Especially when you know that that's a barrier to you even moving forward. It has to be done. So you might as well schedule it right away.
Yes.
Do you get to choose your own mediator? We had a mediator on the show a couple months ago. And of course, we were trying to figure out what kind of matters she handles and things like that. But I know in sometimes the court appoints mediators if the parties can't decide. But in family law, do you kind of throw out a list and say, hey, these are our preferred mediators? Or how does that process work?
So in Pinellas County, it's based on income.
Okay.
So you can choose a private mediator. There's no issue with that. But oftentimes that can be cost prohibitive depending on people's earning capacities. And so that's why the financial affidavit's important because that dictates actually how much people pay.
Right.
So their combined income is $50,000 and below. They each pay $60 each for court provided. If it's between $50,000 and $100,000, then they pay $120 each. And then if the combined income is over $100,000, then they have to get a private mediator.
Got it. So if it's under a certain income threshold, then the court provides.
Yes.
And then they pay just that specified amount.
And the court selects the mediator.
Okay. So I was just about to ask, so is it a certain a list that the court will choose from based on availability or?
Yes.
Okay. All right. So I'd imagine you probably have a good sense of who those mediators are and you work with them.
Yes, they rotate them.
Interesting. So then at the end of the day, not all mediators are created equal. So some are probably more effective than others. So it's just the luck of the draw when it comes to that.
Yes. And that's why a lot of us are, when I say us, family law attorneys, when we have the opportunity to do private mediation. And we do have a lot of mediators now that are matching the court prices or offering reduced prices.
Okay, that's good.
But
they do have to compete with that, price wise.
Yes, but it may result in a wait, and so that's the only roadblock.
Gotcha.
They're high in demand, so.
So when you're going through the process, is that something that you try to get your client to really be open to resolving or reaching some sort of agreement at mediation, or do you think it's beneficial to just get to the judge and let the judge kind of help with the process?
I think mediation is a great tool to try to resolve cases. By the time I go to mediation, I like to have my settlement agreements drafted, ready to go.
The signs of a good attorney.
Yes, I like to have my...
Let's go into this assuming that we're going to reach an agreement, right?
Absolutely. Even if it's on a temporary basis, even if it's on one aspect of the case, like to get valuations or to sell a property, just to try to resolve some aspect of the case, because litigation can be very expensive.
Right. So that was just going to be my next point. So at the point that it does, let's say it does end up going to a trial, you maybe have now narrowed down the issues that you're trying.
Yes.
And so some of them, there's an agreement we've reached on X, Y, and Z, and judge, we're just kind of proceeding on this particular issue today.
Exactly.
That makes a lot of sense. Okay. So then trial. Let's say we couldn't get it resolved. This mediation, unfortunately, we impassed on some issues, and now we've got to go to trial. What can someone that maybe hires you or consults with you about their case, what would they expect to happen during a trial process? How long is it? What kind of evidence is going to happen? Do they have to testify? What does that look like?
Yes. So it really just depends on what we're going to trial on. What's at issue? Parenting issues. There are 20 factors for the court to consider.
Did y'all hear that sigh?
There are 20 factors for the court to consider, and what is important varies from judge to judge, and the presentation of evidence, has to be tailored in that manner at times, but parenting issues tend to be the most time consuming because of the factors that has to be considered and the discretionary aspect of it. Yeah.
So then let's say, just say your average, divorce case where there's parenting issues, there's, time sharing issues, there's alimony issues, child support, whatever the case may be. I don't know. You probably can tell from my ignorance, but what could you say time-wise? Are they 2-day trials, 3-day trials, 1 week? Like, how long does that usually look like?
So my heavily contested parenting issues alone, at least a day or two.
Okay.
Equitable distribution, child support, those issues are more streamlined,
right?
Because it's the statute's a lot more specific in regards to what happens and what the court has to make a determination of. So and then alimony, with the changes in the law in regards to that, it's cutting down on litigation time,
right? Because there's really not much you can fight about then if it's really specific in the statute now, right?
Right. So it's more so maybe fighting about income and that sort of thing. But really, I would say the parenting issues are the most time consuming because it still has a great bit of discretion for the court to exercise. And then you need different witnesses, right? So not just the parties, but also you may want to get some neutral people, the teachers,
So you can call in other witnesses to testify as to what issues.
Exactly.
Like, what kind of issues would you say the teacher might be able to testify to?
So the teacher may be able to testify as to how the child's performing in school. There's behavioral issues. If there are the involvement of the parents.
Yeah.
If there's issues with one or the parents or
the
both
teacher
of
was
them.
aware of.
Yes. And oftentimes, the teachers are the people that are laying eyes on the children on a day-to-day basis.
They see them more than the parents sometimes. Yeah.
Yes.
Wow. So I never even contemplated that. So I never thought about that. My child's, actually, believe it or not, my daughter said to me the other day, she's like, oh, one of my friend's parents is going through a divorce. I said, how did you know that? She said, oh, she mentioned it in class one day. And I said, oh, well, that's sad. But I never thought about that. Her teacher might have to somehow become involved in that process. So that's interesting.
Teachers, coaches.
Yeah.
Mm-hmm.
Wow. Well, so are these trials typically decided by a judge or a jury? How do family law trials
Judge.
work?
Yeah.
So they're bench trials.
Mm-hmm.
Okay. So you don't have to worry about having 6 strangers decide on your parenting plan or how things are going to be divided as far as equitable distribution. That's not being left up to a jury to decide.
No, completely up to the judge.
Good. Which may or may not be a good thing.
Well,
I don't know how you feel about that.
You get to know the judges the more you litigate in front of them, and you know what direction they're going to go on certain issues.
Right.
But it's always best to try to work out your own issues because the judges they don't have the time or the resources to carve out all of these provisions that's unique to your family. And so you have the ability to do that. You have the control of that.
Exactly right.
And you want to maintain that control.
That's exactly right. That's almost similar to what we tell a lot of our clients at mediation when we say, this may be the last chance that you have to really control the outcome.
Yes.
Because once it goes to the jury, you no longer have control of what they're going to do, not for you sometimes, what they do to you. Right. So I can see how that's very true. When the judges are busy, they're not going to give it the same attention and detail that you and your former spouse could by sitting down and trying to agree on it. Absolutely.
And family law is not, it's rarely a win-lose type of situation.
Sure.
I can prevail on, let's say, the parenting issues, but the other side prevails on equitable distribution. But then I did better on the alimony issue. So it's, there's no guarantee that you go to trial and it's rarely ever all a windfall in one spouse's favor.
That makes sense. Especially just the dynamics of family and marriages. That makes complete sense. So I think it's a great time to take a break. We've got a few viewers on Facebook. I hope everyone's been enjoying the show so far. Before we take a break, I just want to let you know that the lines are open. If you have a question, anybody that's watching right now, you've been enjoying what Attorney Campbell has been saying, you have any questions about what she's saying, the number to call is 727-441-3000. Again, that's 727-441-3000, or you can drop a comment in the chat box. Or feel free to share and like the post, send it to somebody. If you think they need the help and want to ask a question, feel free to share it as well. We're going to go ahead and take a quick 2-minute commercial break or so, and then we'll be back with Attorney Kairos Campbell from Golden Key Law Group, answering your questions here on FLA Law live on the radio.
This is the Tan Talk Radio Network.
In 1955, the law firm now known as Pernick, Caulfield, Averill, and Noyes made a decision. Instead of taking whatever cases came through their doors, they decided to focus specifically on personal injury. 64 years later, the law firm is one of Clearwater's longest-running personal injury firms. Available 24 hours a day with offices in Clearwater and throughout Tampa Bay, they're ready to put decades of experience to work for you if you or a loved one has been injured in a car accident or injured due to someone's negligence or recklessness. If you feel overwhelmed, uncertain, or unsure about your next steps after being involved in an accident or after a loved one sustained serious injuries due to someone else's negligence, call Pernick, Caulfield, Averill, and Noyes at 727-796-8282 or online at usalaw.com. That's 727-796-8282 or online at usalaw.com. Non-attorney spokesman.
This is the Tan Talk Radio Network.
And we are back live in the WTAN studios with FLA Law live on the radio. As you know, my name is Jacqueline Bryant. I'm one of the personal injury attorneys at Pernick, Caulfield, Averill, and Noyes. And hopefully you've been tuned in this entire show listening. But if not, if you're just getting in your car and you're turned on the radio, we have Attorney Kairos Campbell, who's here from Golden Key Law Group, who's been talking to us tonight about family law. And we have just kind of dived into divorce and what that process looks like. It's an unfortunate reality that people just have to go through in life at times. And she's kind of been giving us the lowdown in terms of what the divorce process looks like. So, Karis, we did talk about it very briefly. I just want to make sure I get a better understanding for our listeners, though, on uncontested, because it sounds like those are kind of the easier divorces where there's not a lot that we're disputing about. We pretty much agree, and there's no really real disputes there. And so since it's uncontested and it's really black and white, then do you need an attorney for that? Or how does that process look like?
So my rule of thumb, if there's an attorney on the other side, you absolutely need an attorney. 100%.
All right.
Now, if the other side is pro se, I mean, I still recommend that you at least consult with an attorney or, at least have an attorney review whatever agreement that you've drafted. But of course, as an attorney, I'll always recommend that you hire myself or another family law attorney, because here's why. With marital settlement agreements, it's nice that parties are getting along.
Yeah.
However, a lot of people use Supreme Court forms or some of these bare bone agreements that don't include provisions for enforcement.
Right. Or so when things don't continue to get along.
Right.
Yeah. So I gotcha.
When things, exactly. Or when, let's say someone does not comply with the agreement.
Mm-hmm.
What people don't understand is, like, for instance, with equitable distribution,
right.
Once a final judgment of divorce is entered, the court no longer has jurisdiction over assets and debts. It's now a civil matter.
Oh.
So, yes, at least for contempt purposes. Now, the court may enforce certain provisions, but it needs to be specifically outlined as to what you're asking the court to enforce and how they are to enforce it. So, family law attorneys, we include provisions to make sure
a well-drafted aglement.
Exactly,
Mm-hmm.
like specifically, and I've seen this come up time and time again as it relates to real property. Let's say the agreement is to sell the property and split the proceeds. Mm-hmm. Well, sell the property by when?
Right.
What date? Right. What happens when, it for what price?
And it's gone on and on. There's none of those issues were addressed. Mm-hmm. That's when you're going to run into problems.
Yeah, or a buyout, right? Yeah. Refinance. By which date? How long do they have to refinance? Yeah. What happens when they don't? What happens if the property goes into foreclosure?
Yeah.
There's all of these things that can happen if there's no mechanism built into the agreement that protects you. Then at a disadvantage.
Right. So then I guess the short answer to that would be, if you're going to do it on your own, you could be setting yourself up for a lot of issues down the line with the forms not being specifically tailored to you and your spouse and the issues that you're dealing with. Yes. Because when you got the generic forms, it sounds like you could leave a lot of missing holes on, especially in enforcement, it sounds like.
Yes, and a marital settlement agreement, it's a contract. Mm-hmm. So, when it comes to, for instance, if you agree upon a parenting plan, well, a judge still has to find that it's in the child's best interest. So they don't rubber stamp that. Mm-hmm. So at least the judge is reviewing the parenting plan. You might have
agreed on it, but the judge says, sorry, it's not going to work that way.
Right. If it's not in the child's best interest. But when it comes to assets and debts and alimony, you have the ability to contract, even if it's a bad deal.
Gotcha.
So long as there's adequate disclosures.
And so you could make a bad deal because you didn't have an attorney.
Exactly.
And you thought you were getting something reasonable when really you, unfortunately, for lack of a better term, you screwed yourself over.
Yeah.
So definitely don't go it alone, folks. It sounds like even if it's uncontested, you feel like, well, we can reach some sort of agreement. We don't need to fight about this. We can just handle it ourselves. It sounds like the bad option is not something that you really wanted to go on your own and do for the reason that you've already explained, right?
Right. You want to make sure that those provisions are spelled out completely to protect you in case things don't continue to go as smoothly as they were going during the settlement negotiation.
Yeah. Like we said, there's always with matters of the heart and love, things don't always go the way you expect them to. So So we've talked a lot about divorce and we've gone over kind of that process. But when there's a divorce, a lot of times there's children involved and one spouse may need support for that, right?
Yes.
So child support, what is the process on determining or calculating who gets what when it comes to child support?
Okay. So in Florida, we use the income shares model.
Okay.
Which means that the court takes into consideration both of the parties' income, some other things, and the percentage. Well, and that income is used to determine the percentage of responsibility.
Okay.
And that's how the court calculates, what the child support obligation would be. But some other things that the court also considers are daycare expenses, health insurance, who's paying what, and then the amount of overnights that you're exercising with the child, not just time sharing, because that's, a misconception there. Like I had a case where dad was exercising time 12 hours a day, every day.
Yeah.
While mom was at work, but because it wasn't an overnight, it did not count for child support purposes. I was able to get a deviation.
Yeah, I was going to say that doesn't make sense.
Yep.
Okay.
And one day is actually a night.
Wow. Mm-hmm. Okay.
And there's
but there are ways how you can correct that, because that seems like a disparity that you would need to bring to the judge's attention. Yeah.
Well, there's nothing. Most you can do is ask for deviation, and the courts have discretion within 5%.
Discretion to decide.
Not as much as if he had just gotten one night.
And she stayed overnight, or the child stayed overnight.
Yes.
Wow, that's interesting. Mm-hmm. So income, they look at all the factors like health insurance, daycare, things that they're providing. What else kind of goes into the decision-making process on support, child support?
Yeah, so a lot of us have programs that run these calculations, but that's typically it.
Okay.
And so if a parent exercises with about more than 73 overnights, then child support's then calculated according to what's called the gross up method.
Yeah.
And that's where you start seeing some more of the reduction in child support. And there's this misconception that if you exercise 50 times, somehow there's no child support obligation, but that's not how that works.
Gotcha. So I know a lot of people, things change in life. They get new jobs, or the child starts staying more with one parent than the other after there's already been an agreement in place. So what happens when that occurs, where we agreed on something, but now the time sharing has shifted, or my income has changed? What do you do at that point?
Okay. So you can move to modify the child support. The standard for that is if, whatever life change happened would result in child support being changed by $50 or 15%.
Oh, that's it?
That's it. And so, yes.
Wow.
So long as that happens,
interesting,
you can go back to recalculate.
So when they recalculate, then it's basically a resubmission of all the disclosures and things of that nature all over again?
Yes.
Gotcha. Okay.
And there's a provision in the statute that allows, let's say, a parent's not exercising their time, and it's due to their own volition, then that the parent that had to exercise more time due to the other parent's actions, they can ask for more child support.
Right. That's what I thought. So let's say it flips, like one parent is paying child support, but now the child is living with the other parent. Can now that parent ask for child support from the other parent? Okay.
Yes.
But they'd have to go through that whole process of asking and doing the disclosures and so forth.
Yes.
Okay. So if there's a person, let's say they're paying child support right now, everything is happy, no one's raising a fuss, the child is happy, the parent is getting their support, but the one parent has now gotten a promotion, they're making a lot more money than they used to, but nobody's saying anything. I'm just going to keep paying this little bit that I've been paying. Is there any obligation or duty on a parent's behalf to notify the court of any change in their income?
So not unless it's specifically built into the final judgment or.
So if there's no provision saying you must notify me if your income increases or whatever and things like that. Wow.
And then there's no,
So you can just keep paying whatever that minimum was or whatever the agreement was, even though they could be making now 6 figures or whatever.
But you'll know. Then the kids tell you too. I mean, honestly, the kids are the biggest snitches as to what's happening. Yes. Oh, Dad got a new car. Oh, Dad, we're going here.
Things are the flags are now coming up. Like his car got nicer. He's got a haircut every day.
Yes.
I got you. So that's really the only way to know, though, is if something starts to indicate to you that there's more income coming in that you might want to pay attention to.
Yes.
Okay.
That's oftentimes how it happens.
I wondered if there was ever any duty or obligation to disclose that.
No.
Interesting. Good to know. So then we'll get down to equitable distribution because we've mentioned that a few times, and I don't know if our listeners have any idea what that means when it comes to a family law case. So what is equitable distribution? And how does that come into play when trying to reach some sort of agreement, or if the judge ends up deciding it? What does that mean?
Okay, so equitable distribution is basically the division of assets and debts that were acquired during the marriage. There is a presumption that all of the assets and debts acquired from the date of marriage until the date of filing are marital.
Okay.
And that they are to be split 50% each.
So if they were acquired after the date of marriage. So anything that you came in with student loans, credit card debt, or anything like that is not necessarily considered marital, a debt or asset, right?
Correct. Okay. So if it's premarital, so it can there's ways that
it's complicated, I'm sure.
Yeah, it can get complicated because there's ways that premarital or non-marital assets it can be converted to marital depending on
what you do. That's what I've heard, right? So and maybe I'm not able to explain it, but I've heard it's kind of like businesses where maybe you had a business before, or let's say property. You had a property before, but now you've remodeled it and you started renting it out and doing all kinds of different things during the marriage that maybe you weren't doing before. And now it can kind of convert to some extent, right?
Yes, there can be a marital portion, a marital interest created.
Right.
Because income that you earn during the marriage, that's marital income. Right. So if marital income is being used to conduct renovations and engage in what we call active, work for active appreciation, then the spouse isn't, may be entitled to their marital portion.
Right. So there's no, I bought that before we got married. That's mine. That stays mine. Yeah. Not anymore. It's now somewhat converted, right?
Same thing with retirement. So if you have a retirement now, and then you get.
So how does that work?
So let's say you're unmarried, you have a retirement, and then you get married and you start contributing your marital income into the retirement. Well, whatever was contributed from the date of the marriage until the date of filing, that's the marital portion.
Sure. So let's say we're just going to use some rough numbers. Let's say before your marriage, your 401k had $100K in it or something like that. We'll just use round numbers. So you had $100,000 in your 401k, and then during the course of the marriage, you contributed another $100. By the time the divorce is filed, there's $200. We're just using rough numbers. So you're saying 100 of that could be considered a marital asset?
Will be.
It will be. Interesting.
So the other spouse will be, entitled to $50,000 of that.
Wow. Okay. So I guess we got it off a little bit on a tangent. So when the courts so that's what equitable distribution means. Basically looking at what assets are marital and non-marital, and then how do they decide what's equitable though?
So the presumption is that if it's marital, it's split 50%.
Okay.
And
so 50-50 is kind of the rule. I wasn't sure if that was really what it was.
Yeah, that's the rule. So we basically take all of the assets and debts that we believe are marital. We put it in a chart or really like a spreadsheet, and we divide it in half. Or start, or depending on which assets or debts people want to keep, we start moving it to try to make sure that the bottom number results in them having the same net worth.
Gotcha. Okay. All right. So then what if let's say one party has a lot of debt or credit card debt or student loan debt or something before the marriage, and then as they're married, that debt accrues and it just continues to grow. Maybe they're in a deferment or they're still in school or something where the debt just gets higher during the marriage. So does that spouse then take on that debt as well, or is that still considered like a premarital thing?
So it would depend on whether it's like passive or active, right?
Uh-huh.
So, and the same thing with assets. So if the value increases or debt increases, if it's just market or interest rates, that sort of thing,
Nothing that doesn't did to change it, okay.
Right? That doesn't change it, but if let's say she went to school,
added more to it,
right?
Gotcha.
Increased her student loans,
gotcha.
Then that's where it gets. And
or you did, let's say you had a property and you did something to increase the property value, and not just let it sit in its own natural, like you said, from the market.
Yes.
Okay.
Yeah.
Interesting.
Now, the statute does outline, too, there are ways to overcome that presumption of 50-50.
What are some examples of that?
So it can be, the most common is depletion or waste.
Okay. What does that mean?
Of assets. So, for instance, if someone used marital money to gamble or for extramarital affairs or in an irresponsible way, then there's you can ask for the court to issue an unequal distribution.
To consider that. So that it won't be 50-50 based on those factors.
Yeah. So there's a number of factors that the court can consider for an unequal distribution.
Okay. So we did talk about mediation, how that's something that must occur before you ever get to see a judge or go to a trial. But is there ever a time where you are encouraged to counsel or go to counseling if you're going through a divorce or having to deal with all these issues with children and time sharing, parenting plan, or however it's phrased nowadays? Is there ever a time where you say, look, we should go to counseling here? I recommend that you try counseling before we go forward in the case.
So I always recommend to all of my clients to go to counseling because the divorce process, a lot of times it can get worse before it gets better, especially if it's contested.
Sure.
But also for people that aren't sure that they want to be divorced, and if the other side's, back and forth as well.
And you can tell that there's some sort of back and forth going on.
Yes. There are times where
or they're going through divorce, but they're still living with each other, or they're still sleeping with each other.
That happens too. We'll put the case in abatement, meaning put it on pause. And, I tell people, like, look, give it one more shot, go to counseling and see if you can work it out. Yeah. There are times where people will try.
Yeah. But it's not required. It's not a part of the process.
It's not required. Okay. And really, the court, only one person needs to want the divorce for the court to find out.
So the court doesn't care whether you tried to work it out, went through counseling, did any of that. That doesn't matter.
No. And the court can't order for those purposes.
Right. Got it. That's interesting. Now, what about when there's children involved? Did they feel like, is there ever a time where the court might feel it's in the best interest to have counseling for a child?
Oh, absolutely.
Okay.
Family counseling, individual counseling. Let's say that a parent and a child are estranged or having some issues. Unification counseling. We use a lot of we call it therapeutic justice. In family law.
Yeah, well, that's awesome. I think, does your father do some stuff like that?
Yes, he's a therapist.
Shout out to Dad. It's always wonderful when the careers and the work that you do can overlap like that. Okay. So we talked about counseling, divorce, child support. Alimony is another issue that I think is kind of big when you go into the divorce process. I know it has recently changed a bit in the law. So I just want to touch on it kind of quickly to understand what is alimony. Are there different kinds of alimony that you can get? And are there certain requirements as to whether you can be entitled to it or not?
Yeah, so there has been a drastic change in the alimony law that has had
preaching to the choir. All the personal injury lawyers out there know what I mean.
Yes.
Laws are changing.
We have been in a frenzy trying to figure out, how it's going to play out in court, the appellate court. when the decisions come down.
Yes.
But in July of last year, DeSantis got rid of permanent alimony.
Okay.
So their permanent alimony no longer exists.
Right.
So as of right now, we have bridge the gap alimony, rehabilitative alimony, and durational alimony.
Okay.
And so alimony is determined based on a spouse's need,
right,
and the other spouse's ability to pay.
Okay.
That is the threshold to begin with.
So one spouse may need it, but if the other spouse can't pay it, then there's no alimony.
Right.
Or one spouse might be able to pay it, but the other spouse may not even need it.
Exactly.
Gotcha. Okay.
And that's what a lot of the litigation actually, ends up being
right,
on. And we're
right,
going through the expenses and no, you don't need, $500 a month on vacations. You don't, we're picking apart their living, their lifestyle.
Okay. So then what is the difference between bridge the gap and rehabilitative? Because that sounds like the same thing in my mind.
Yeah. So the difference between bridge the gap and rehabilitative. So bridge the gap is basically, it is to help a person that was married adjust to single life.
Gotcha.
So it's now a 2-year cap.
So it's a very short period of time.
Very short period of time, perhaps.
No more than 2 years.
Mm-hmm.
Gotcha. Okay.
And rehabilitative is basically to help a person be self-sufficient, help a spouse be self-sufficient. So let's say they've been out of the workforce for quite a bit. They may need to do some certification courses, right? Or go back to school. And there has to be a detailed plan set forth. And that cap is for 5 years.
5 years.
Mm-hmm.
Okay.
Yep.
So we're talking very short periods of time here when we're talking about the new alimony standard.
Mm-hmm.
So what was the other one? We talked about bridge the gap, rehabilitative, and what was the other one?
And then there's durational.
Okay. So that could be a little longer.
Yes.
Okay.
So so the new statute or the revisions also changed the length of marriages. And
right, that was another thing. So you have to be married for a certain period of time, right?
Yeah. So if you're married for less than 3 years, now you're not entitled to alimony at all.
Get out.
Yeah.
So people that are contemplating a divorce, you haven't hit that 3-year mark, you might want to hold out a little bit. Yes. Just hang in there until the 3-year mark.
Incredibly difficult.
That is so funny.
Incredibly difficult. And then from 3 to 10 years, that's considered a short-term marriage. 10 to 20 is considered midterm, and then 20 and over is long-term. So it has changed.
So based on where you fall, could predict how much you may be entitled to.
Correct.
Gotcha.
Under the durational alimony setup, because basically, let's say you're married for 3 to 10 years, then you're only entitled for the length of time, like 50% of the length of the marriage. And then 10 to 20 is like 60%.
Oh,
and 20 and over is 75%.
That's a lot of math.
A lot of math, and we don't like math. That's why we became lawyers. Yes.
Reason number one why I didn't go into family law.
Yes.
Karis, there is so much that we did not get a chance to get into. Look at the time. I do not want our listeners to not have a chance to reach you. So please tell our listeners right now, how can they find you online or by phone so that if they have questions or they want to consult with you, how can they find you?
Yeah, so we are on Facebook. We do have our website. Our website's goldenkeylawgroup.com. And our phone number is 727-317-4738, 727-317-4738. We offer very affordable consultations. Please give us a call if you have any questions or concerns.
Definitely reach out to her, folks. Of course, if you have personal injury lawyers, you can find personal injury questions. You can find us at voiceoftheinjured.com. We thank you, Karis, for coming in. It's been a pleasure. Of course, we'll have to have you back again to talk about some more family law matters. But folks, that's our show tonight. We will be back next Tuesday at 5:00. As always, we'll have a special guest, a criminal defense lawyer, Zachariah Wade, will come through and answer your questions. Until then, we'll see you next Tuesday at 5. Have a
WTAN, Clearwater,
FM 106.1,
WDCF, Dade City,
FM 102.3.
Listen.